to go. All right, so let's get started, Bibek. I'm going to pin your video so you can kind of start presenting. Welcome.
Thank you. Thanks for the kind words, John. And yeah, I appreciate it. It was great working with you, and I'm happy to meet everybody. Unfortunately, it's not in person, but it sounds like maybe soon we will be. So keeping our fingers crossed on that. But glad to see everybody seems to be doing okay. So I'm here to talk, as John mentioned. I have a pretty large practice where I would say I spend 50% of my time dealing with litigation, mostly real estate based litigation. I do some commercial litigation as well. But then primarily I do real estate transactions, do corporate transactional work. And something that I'm going to focus on today is, asset protection, mainly focusing on LLC formation as a real estate investor, and the pros and cons, essentially, and why people do this. And I'm sure, I've already spoke with one of the individuals, Dave, and he had some poignant questions. So it sounds like, probably a few of you already are aware of it, but I'll go into some of the details and the nitty gritty of things that I've seen in the past. But just from a general standpoint as to why we talk about asset protection and what comes up and what everybody needs to be aware of is, I'll tell you right off the bat, real estate is probably one of the strongest magnets for lawsuits, because you have risks from all aspects of it. You have risks from buying, selling, ownership, tenancies, and it really puts the liability exposure for an owner, it makes it very high. And so there has to be considerations there. And, in terms of making the juice worth the squeeze for buying a property, making a property investment purchase, you have to take into consideration what's your potential liability. Nobody has a crystal ball to determine, hey, what are all the different things I can get tagged for? And what could I have exposure for? So, but as attorneys, our job and our kind of obligations to our clients is to, advise them, hey, these are your options. And the best way to try to protect these things are various things you can do. But ownership of the property and putting it in an LLC is probably like one of the most important things that you can do. So one of the things that I talk about, I try to break it down to two different aspects. You have inside liability. As an individual, you have inside liability, and what I consider inside liability would be the property itself, the tenancies, the ownership of the property. That would be considered inside liability, because this is an asset. You purchase this property. So it has value and it has an inherent value and then you have liability also possibly to lenders as well, depending if you own the property free and clear or if you have a loan on it. Then you have on the other aspect, outside liability. You own this property, you have this asset, but your day-to-day life, you might, investment properties might be something that you do as a side hustle with some extent, but you have a full-time job and you run some kind of business or practice, and you just in your regular day life driving a car, you have outside liability there. An example that I can use is if you're driving a car, you get in a car accident, something happens to the other driver and they have to, you get sued. Guess what? This investment property is in your name. It's an asset and it could be exposed. If you don't have enough insurance coverage, it's considered an asset like much of your other belongings in your life, as well as your own home. So, as an investment property owner, how do you protect against that? Well, the beautiful thing is you can protect both inside and outside liability by just setting up an LLC. So from that aspect, I do recommend to clients and to investment property owners to set up LLCs or put their properties in LLCs. Maybe one, maybe many. And some of those, every LLC creation for investment property reasons is really a case-by-case basis. And so I would like to say, as just kind of a disclaimer, things I'm going to say today might not pertain to you specifically, and definitely confer with an attorney, whether it be me or anyone else, as to what you should do. Really, everybody needs to have a really good understanding of your portfolio, and have a really good understanding of what your assets are, what your potential liabilities are, what type of properties you own, um, and investment groups as well. So the good thing is, the LLCs were created. So when I say relatively new, but I mean, it was created, I think, around the mid 70s, essentially to make it easier for people to create businesses. And what LLC stand for is a limited liability company, meaning you're limiting your liability. That is the sole purpose, not the sole purpose of it, but it is a purpose of it. You've also got tax implications, and there are other reasons for it, for tax write-offs, etc. But really the main purpose people go in is that, hey, I want to get into buying a property, and I want to make sure that I am protected as best as possible. My family and all of my personal assets are protected if anything were to arise out of this property that I now own. There are other forms of companies that can be formed that are corporations. You've got partnerships. I'll talk about the pros and cons just from a general standpoint. Like, corporations have really strict restrictions on exactly how they're operated. They're kind of complex tax implications as to corporations, as well as record keeping, so even the bylaws, the minutes, etc. All of those things have to be done. And if they're not done properly, it can absolutely expose the people who are involved in those companies. Partnerships, essentially, they help with minimizing tax issues, but they really don't give any liability protection. I consider that like kind of a passive. So partnerships, if you have a partnership with somebody, you're not protected from liability from yourself, from anything in that sense. The other thing that I tell people is the limited liability companies are created. You have what normally you would call an operating agreement. Now, they're not required, but the operating agreement is essentially your governing document. You set up your LLC, and it's actually pretty easy to do. And I'll talk about how you can do it in Illinois, just generally speaking. But you have an operating agreement. The operating agreement governs exactly how the LLC is run, and it governs the relationship of the members. So automatically, you inherently have limited liability when you create a limited liability company if you're a member and your LLC is operating in good faith, in good standing. So when you have an operating agreement, that actually creates the relationship between the various members. So LLCs have members as their owners. That's who the owners are. So it could be a sole member, it can be many members. Specifically, no member is personally liable for the obligations of the LLC. That means an individual member can't be sued. So if you have an LLC, you as a sole member or you as one of 5 members cannot be technically sued individually if you have something that arises under the LLC and you get sued for something involving a tenant, etc. The one exception, this is actually something that came up somewhat recently when I was talking to an investor and didn't realize this, kind of found it curious, is sometimes you may have set up an LLC and you get a loan and you buy a property with the loan with the LLC approved as the owner, but that lender requires a personal guarantee. In that scenario, you have a personal guarantee, you're going to have liability of the lender for the loan that they're giving. So that's an example of where you don't get 100% LLC protection or limited liability liability protection as an owner. The other things that are to keep in mind is that if you don't maintain your LLC, or it's essentially what they call a sham corporation in some way, where it's just clearly being run in a way that is, you're commingling funds, you don't set up accounts under the LLC, and you have a personal account, and things are not being run correctly under the requirements of LLC, then somebody can try to sue the LLC. And if let's say you're involved in a lawsuit, discovery comes up and it's determined, they can go ahead and try to pierce through the veil, which is what that's called, is they'll pierce through the veil of the LLC and then go after the individual owner. people, if you have questions about that, I can go into that in detail, or give examples of that. In focusing on, I'll focus on Illinois. Setting up LLCs in Illinois is not very expensive. It used to be about $500 a pop. It's now about $150. And then you've got your regular yearly annual renewal fees, usually about $100 that you have to pay to maintain the LLC and keep it in good standing. So it's not really a crazy expense. There are tax implications and there are tax benefits that you can get from it. Expensive just even setting up the LLC and the costs associated with them. They're business write-offs, and I'm not going to provide opinions about tax things, but I do know about it. But from a general standpoint, there are protections and there are things, that tax advantages that you can get from having an LLC and how it's treated under the IRS and with their tax code. Now, in setting up an LLC, you have your members, you have an operating agreement. The operating agreement governs how the parties have their interests. And most people probably have heard of shares. And under corporations, you have shares. In LLCs, you have membership interests. So everybody has a percentage interest. And the operating agreement will govern how things are done, how votes are done, how decisions can be made. You have one option is called a member managed LLC, where all the members have ownership interests and all the members delegate the duties of the operation of that LLC. It can be done by vote, and you can have 2/3 vote for you to be able to do certain things. That can be spelled out in the operating agreement. And the membership interest will govern that. So if you have 4 people that have 25% interest, all 4 of them have 25% interest, and you're going to need 3 people to vote to get something approved. The other option is a manager managed LLC. Those are particularly, I like those for purposes of, it streamlines everything. You have one manager who is appointed by the LLC. All the members agree to appoint that manager, and that manager can have the duties and obligations. They have a fiduciary obligation to make sure the best interests of the LLC are taken care of, as well as the members. And they can make the day-to-day decisions. And their name is the one that, if you go onto the Secretary of State's website, you will see their information as being the manager, and they will be the ones that will, if somebody wants to pull up for public record purposes, who owns this LLC. I think Dave asked this question earlier about trusts and whether a property should have been owned in a trust. And I think it was actually quit claim to an LLC. You can actually have a trust as a member. So that member actually, the trust, and I'm not going to go into too much about trusts and living trusts. That's a whole different level of asset protection from individuals, because that entails personal information about your family, etc. But a trust can be the member, and it'll have the membership interest in the LLC, and it can make the decisions, and it can get its benefits and the payouts based upon their percentage interest from the LLC. So that is another option. It essentially creates another layer of protection. So if somebody's going to try to pierce a veil, as I was mentioning earlier in a lawsuit, the exposure to the members then is protected one more layer by the trust, because somebody has to then pierce the trust. So you've got 2 layers. I did mention that I'm kind of focused on Illinois, but yeah, I'm sure a lot of you have seen that people set up LLCs in Delaware or other states, and some of the reasons for that is just that they have beneficial laws that benefit LLCs more than other states. If you own a property in Illinois, it's probably best to just own an LLC in Illinois, but you can have a Delaware LLC doing business in Illinois. But there are a lot of nuances that come with that, in terms of, you have to register the LLC. You're going to be paying Delaware costs for setting up that LLC, as well as you have to have that LLC registered as doing business in Illinois. So there are various things, but there are reasons that each individual might have for setting up an LLC from another state to do business here. Now, as I was saying earlier, the name of the game is to protect you as the individual and your personal assets. I One of the questions that I get a lot is, can I do series LLCs, which I'm sure many of you are aware of, where you have a parent LLC, and then you just create sub LLCs. The reason for that, I mean, it's relatively new in Illinois. It's only about 5 or 6 years old. It is something that's common in Delaware. And that was just to really save headaches and costs and just leave something under one umbrella. Accounting purposes, it made sense. But as I was saying, I do litigation. I'll use this as an example because sometimes I feel like examples make it better to understand. I had a client who had a series LLC in Illinois, and the requirements for setting up a series LLC in Illinois requires you to have the name of the parent LLC under each series. So that means that if your parent LLC is John Warren LLC, then the other one the sub LLCs will be called John Warren 2 LLC. The name of the parent LLC has to be in the sub LLCs. In this scenario, the LLC had allegedly breached a contract with a vendor. The vendor sued the parent LLC, which is the wrong LLC, because their actual contract and their negotiations occurred with John Warren LLC 2. And part of the protection of having an LLC is also anonymity. In that scenario, we had to go through the whole litigation aspect and go ahead and file a motion to dismiss, saying, hey, you named the wrong party. Actually, the LLC that you should have sued was LLC 2. But they were able to pull up the parent LLC and drag them to court, and you had to get it out of court. And part of the reason a lot of people, as I was saying, get the series LLC is because it's cheaper to some extent. But if the ultimate name of the game is to protect your keep the anonymity and protect each of the LLCs, then sometimes I say it's not maybe the wisest choice. It's better to have one LLC called John Warren LLC. You can call the other LLC John Smith LLC. So nobody knows that, hey, the members might be actually the same and they might be intertwined in some way, but nobody wouldn't be able to, unless they did a lot of digging, would not be able to determine that those same entities have the same members and might have the same target that person wants. So from that aspect, as I was saying earlier, before it used to be $500 a pop for an LLC. Now it's $150. So it's much cheaper to just set up a regular LLC. So from a multiple property standpoint, I usually recommend, hey, set up the LLC for the property address LLC. So it's like 2154 Dorchester, then call it 2154 Dorchester LLC. And if you buy a property, on 3555 Cannon, then you call that 3555 Cannon LLC. It could still be you as the owner, but they're totally not. They're totally two different LLCs. And the reason for that is, let's say you get in a scenario as an investment property owner, you've got a tenant and something horrible happens in that tenant, or let's say an invitee comes in and they sue you and you have significant damages. Well, what's your exposure? The exposure is going to be the assets of that LLC, not you as the owner, unless you haven't been running the LLC correctly, but just that LLC. And if that LLC only owns one property, the one on Dorchester, then that's all that's at stake. Now, if that LLC now owns 5 properties, all of those properties are at stake because all of those are considered assets of that LLC. So I usually address that issue from a case-by-case basis based on value of the properties, the potential for exposure. But when it comes to multiple properties scenario, sometimes if you have 2 $100,000 properties, and it doesn't maybe make sense to set up 2 separate LLCs for that, but everybody's got their own risk tolerance, and that's probably the reason why some people will do it one way or the other. Now, again, the other important thing that I was saying is you're also protected from outside liability. All right. Now, and you're not fully protected as an owner in terms of the LLC's assets. But if let's say you run a business and you get sued, the LLC is technically the owner of this property. So that you have to pierce again through that LLC to get at that asset. And if you have multiple members on that LLC, to get to that asset of that LLC will be very difficult for somebody if one of the members somehow gets sued for something. The worst case scenario is if that member gets sued, only thing that's at risk is their membership interest, and then they could get a court order that requires, payment of such judgment for that individual member to come out of the ownership of the LLC. So any kind of dividend payouts, et cetera, that are done through the LLC would just go to that members, but the LLC still can run. They don't lose the property, and you're not exposed from the outside liability. So I can talk about some of the other things about like setting up the principal address. You always required, by the way, in Illinois, you have to have a registered agent that can accept service of process during normal business hours, which would be 9 to 5 at a location in Illinois. It has to be in Illinois. So you have to have a registered agent. It can't be a PO box. So some people might use their residential home. Some people might have an office you can use, or you can ask your attorney to be your registered agent. The registered agent services, they charge a fee for that. But essentially the purpose of that is that in the event the LLC needs service from the Secretary of State or gets sued or gets service of paperwork, there has to be someone in Illinois. So an outside member people who live outside of the state can be members, but and can set up an Illinois company, but they're going to have a registered agent in Illinois to ensure that there's someone there to accept paperwork. So that is another thing to consider. In terms of anonymity is another thing that we're talking about. And I guess the best way to protect, there are many things that I've seen done where people have LLCs that are members of other LLCs. And so you'll see if you go pull up on the Secretary of State's website, you want to pull up who's got management interest or membership interest in an LLC, you can kind of pull it up pretty easily on the Secretary of State website. You just go and do a search and look for the LLC, and you can find who the members are. And sometimes the members will just say Joe Smith LLC is a member. It'll have their address, but you won't know who that individual, or there could be members under that LLC. So you can have multiple layers. So that anonymity is another reason. Again, what I said earlier, you can assign a manager, and the manager is manager managed. So when you do look at an LLC and you pull it up, it might, if John Warren is my manager, it'll only show up John Warren, but you don't know who the other members, Dave, Bibek, John could all be members, but John Warren is going to be the only one that shows up as a manager. So that's another consideration to take into place. So that's kind of like, in a nutshell, a really quick overview. I don't know, John, I'm sure you're there, but if people have questions, I think I can field them now.
Yeah, this is a perfect time for like a Q&A session. I mean, I know everybody's in a different spot and everybody has, different questions. So why don't we open it up for the audience? Anybody has a question for Bibek, jump right in.
I had a couple questions.
Hi, Jesse. Yep.
Hey, so could you talk about the timing of setting up the LLC to put your property in? Is that something that you need to have set up beforehand, or can you do it after? And then my other question was, is it really okay for you to set up your registered agent as like your home address? I think I've read things saying that you're not supposed to do that.
Okay, let me answer your first question. So let me get the timing. Okay, couple of different things when it comes to the timing. It's relatively quickly. You can do a rush. You have to pay extra for that, and I forget what the rush fee is. I don't know off the top of my head, but let's just say for all intents and purposes, another $100. So like instead of 150, it's 250. So you can get a rush LLC created. One of the things I forgot to tell you, did mention also, when you're setting up an LLC, you got to make sure that the name is not taken or not similar to another name of an LLC, so there's any confusion. So part of the due diligence aspect of setting up an LLC is you got to ensure and that there's no, I'm pretty sure there might be a John Smith LLC. So if anybody here wants to do a John Smith LLC, they'll probably have a difficult time. They'll probably get rejected by the Secretary of State. So that being said, that can take some time off the time in which you need to set up an LLC. You can create an LLC at any time, but the question is when are you buying the property? If that's what your intention is, you're buying the property, here's the thing, you're going to have a record. You're going to have a deed that's recorded. So if you're going to have a deed that's recorded and it's in Jesse Wilson's name, Jesse Wilson bought this property, you got a deed that exists. And then you're going to do a quick claim to an LLC that you formed later after the fact. Totally fine to do, but somebody can actually pull up on record, hey, Jesse Wilson is here, and then you quick claim it to Jesse Wilson, John Smith LLC. Kind of defeats that anonymity purpose. So from a perspective, hey, you want to create the anonymity, you're going to still get the LLC protection. That doesn't mean that goes away, but part of what people want is anonymity sometimes, and they don't want their name tied to the property. So the best way to do is set up an LLC. Now, that being said, that also the nuance to that is if you're doing it based on a lender and you're getting a property with a lender, you're going to have to make sure you clear that up with your lender first and let them know, hey, I'm going to buy this property, but I want to own an LLC. So their underwriting has to clear that. If you're buying your primary residence, they're not going to let you own a primary residence under an LLC. But investment properties, totally different story. And it also depends on the lender. So that also may change the timing perspective of things, because the lender may say, hey, before we can close and fund this deal, we need to have the LLC set up. We need all the paperwork, we need the operating agreement, et cetera. I'll get to your other question, Jesse, but another thing that popped in my head also, LLC, very important. You need to set up its own operating monetary account. So like it should have its own separate bank account. It cannot be your personal and Jesse Wilson's bank account. You're going to have, every bank knows how to do this. You come in, and this is when I say, hey, although Illinois does not require you to have an operating agreement, most banks won't let you open up an account unless you have an operating agreement. Jesse, to address your second question, yeah, you're correct that you should probably not use your primary residence. Sorry, John's popping. I think you just typed something, but I'll take a look at it in a sec. In terms of, I again, anonymity is probably the biggest reason why I wouldn't want to put my personal residence as my registered agent. Okay, so I have Jesse Wilson LLC. I mean, right there, your name's on it. But now you've got where's the registration? Oh, Jesse Wilson at wherever your home is. Don't tell us, Jesse, but that defeats the purpose. But nobody's really checking that. That's not something that I would ever say is, oh, you're going to be in violation of something that would cause you to have some exposure. I mean, people are working from home. As long as you're able to get service of process and somebody's there 9 to 5, that should really be the location where you want your registered agent. But I see people all the time use a primary home address.
Bibek, we had a couple of questions that before I figured out how to get where people could ask them in the chat. One of the questions was, what's the difference between an LLC and an S Corp?
Okay, well, this is kind of funny, confusing question, because S Corp can mean two different things. There's S Corp, C Corp for partnerships or for tax purposes. And that means that's completely has nothing to do with liability. All right. So S Corp is really a tax designation. It's like, how is the company being taxed? How is it issuing dividends, all that stuff. I'm not going to get into that because that's something that you want to talk to an accountant about for sure. You should always talk to an accountant about tax implications of setting up an LLC versus an S Corp. Well, when I say S Corp, the true meaning that from a legal entity standpoint, there's no such thing as an S Corp. It's called a corporation, just general. And a corporation has, as I was saying earlier, you have bylaws, you have shares that have to be issued, you have really strict restrictions on how corporations can be done. And I didn't want to really go into that. That could be a whole other presentation. But for purposes of people who have investment properties, and if you're not a huge shop, there's there's no benefit to a corporation. Companies like McDonald's, they're going and raising funds. That's why they are corporations. There are other reasons for that, and there's reasons why those are situated in Delaware, et cetera. But LLC was created to allow everybody to have business, and that's a benefit of it. It's really an easy thing to use for all intents and purposes when it comes to setting it up. It's not complicated. You don't have to do a lot of things in terms of maintaining it. You do your bare minimum, you set up your accounts, you have your operating room, you abide by it, and you can keep continuing to make sure it's in good standing and do all the things that Secretary of State requires you to do. You're good. Corporations, you have to have minutes, you don't have to maintain minutes. Like, that's probably the biggest pet peeve that people have in corporation. You have to have meeting minutes, you have to maintain the minutes, you have to maintain a lot of paperwork. So for most people purposes here, I would assume that doesn't apply. So that would really be the difference if the question was meant to be, what's the difference between LLC and corporation?
Bibek, another question that was thrown into the chat earlier that I couldn't share with the group easily, has to do with, what kind of properties can you put into an LLC before you buy them versus like obviously a lot of people use conventional or FHA financing and you really cannot. Maybe can you talk a little bit about that?
Yeah, well, I mean, that's really going to be, if you're getting FHA loan, you're not going to be able to, period. That's not going to happen. And I was saying earlier, like, your primary residence is not going to go into an LLC. But for investment, if you're going in, you're getting hard money loans, et cetera, or you're getting investment property loan, which has different terms. Yes, those can go into LLC. But the most important thing is you have to address it with your loan originator right up front. Like, don't wait till like the day before closing and be like, oh, can I just go put this in an LLC now? Oh boy, you're back to square one. You're going to have problems. You're going to have problems in your transaction. The buyer's going to go crazy, or the seller's going to go crazy. And you're like, hey, well, I can't close. And then you get back again, you're forced to close, and now you get to go transfer the LLC. Well, there goes your anonymity, because you're now stuck with the deed with your name on it. And now you're going to quit claim that to the LLC. So there's going to be a history of a deed with your name on it and it being quit claim. So do it immediately, do it up front. But FHAs aren't going to let you do it and I'll defer to the lenders on that. Their rules and requirements. You're not going to be able to pull that off.
What about like your conventional, your person's buying their 2, 3, 4 unit, maybe single family home using 20% down conventional. Yeah. They still don't let you buy in an LLC, right? Or have you ever seen any changes on that?
No, I mean, it depends on the lender and it depends on the type of loan. I mean, if it's a conventional loan, if it's an investment property loan, if you're getting more of a commercial loan, especially for a multi-unit, they're going to allow it. But that's something I would defer to the lender and the type of loan package you get. If you're utilizing the property and I don't know, John, if this is the kind of the question that's being asked, because if you're talking about a multi-unit, John, you own your own home. It's in your name, right? Now you're going and buying an investment property with 4 units. You're not living in that property. I don't see why you could not put that into an LLC. But if you're living in one of the units, then that's a different story.
Yeah, I mean, neither of us are lenders, obviously, so that's always the tricky part. But I mean, I know that,
and I don't want to give that advice and say, hey,
right,
you can or cannot do it, but that's going to be on a case-by-case basis, depending on the lender and the type of loan.
For what I've seen, I mean, just at a high level, it's really hard to buy using those really cool terms you get with conventional financing, really low interest rates and everything like that, and put it in an LLC and have that asset protection. So that's, at a high level, that's what I've seen.
Well, yeah, and again, the name of the game is that for the lenders, that they're going to protect their assets as best possible. So they need some recourse, right? So what I was telling you guys before, they may allow you to have the LLC, but look, if you have 4 members, all 4 members are going to have to put personal guarantees on. Then they might allow it, right? But they don't want a situation where, hey, I got 4 members on this LLC, but one person, you're going to have to fight it over. Maybe the lender will allow one person to guarantee it, but then that one person is going to be like, well, I've got the guarantee. What am I going to do here in this scenario? Like, John, you're with Dave and me. And they're like, we'll take John's guarantee because John has the most assets, so he can protect this loan. They might allow it in that scenario. And probably that's true, John. You're probably the richest of all of us, right? So they will, but in that scenario, like that's the reason why you might have problems. And again, if the lender's gonna, if you're going in for investment properties, your your loan terms are obviously not going to be the most favorable. You're not going to get like a 2.8% interest that you're seeing on conventional loans because it's an investment property. So there's an inherent risk with that. There's an inherent risk for the lender because guess what? There's going to be tenants in there. So they have to hedge their bets. So, but I'm not saying that they wouldn't, but it really depends on a case by case scenario and some of the scenarios I just brought up. Like if everybody's able to give a personal guarantee, some lenders will.
Bibek, I think a lot of questions with this, maybe you could sum it up like this. Like, at what point do you feel like somebody is too small to worry about getting a corporation? Like, for instance, I work with a lot of people early on. They're like, I have $5,000 in the bank. I want to buy an investment property. Do I start my LLC? And I'm like, ooh, sounds terrible, right? Like, at what point is there like a tipping point you've seen where it's like, all right, you've got enough assets where you should really start to get worried? Or like, what's your thought process just from a high level?
So I get asked that question a lot, and it's a great question because it's really hard. And like, look, yeah, I set up LLCs as an attorney, I get paid for it. I have no problem taking food out of my mouth because I need to do right by my client every time, ethically. The thing, if you have like no assets, then what are you protecting against, right? Now, you could have a judgment that follows your name, but you could file bankruptcy to get rid of that judgment. So in that scenario, maybe, yeah, if the LLC has a judgment, you could just fold the LLC and BK the LLC, right? So from a personal standpoint, if something were to happen, you got sued related to the LLC, you could just wipe that liability off the bank. The LLC itself BKs, but you as a person do not. But by the way, you as a member, if let's say you're a sole member in this scenario, that bankruptcy will still follow you. In the future, if you have to get a loan and you're like, hey, did you ever file bankruptcy? Well, that technically you'd be having to check that box because you're a sole member and you had to file bankruptcy on behalf of an LLC. So like from that perspective, I want to say that. But yeah, if you don't, there's a lot of that weighing the risks and reward of having the LLC. And that's one aspect of it, is like, what are my assets? And two is like, are you gearing this up? Like what people tend to do, and I'm going to tell you guys, admittedly, like it's like about setting up wills and trusts. A lot of people just put that stuff off. And the next thing you know, you have a lot of assets and you just didn't do anything because you just pass it off. So, from one scenario, if you're thinking, hey, this is something I'm going to grow, I know I'm going to buy more than this property and I'm going to have more assets. Maybe for that purpose, hey, look, I already have my LLC in place and now I can go buy 3 more properties and the LLC is ready to go. But more often than not, depending on the scenario of each individual person, like if you don't have many assets, the cost benefit is probably not that great.
As a sort of follow up, maybe I own a bunch of LLCs, or I have a bunch of LLCs, and it always shocks me how much it costs to keep these little guys afloat every year, even when I just do normal stuff. Like, what do you estimate it costs to not just start the LLC, but to maintain the LLC with an accountant and an attorney and things like that? Is there like a ballpark for a newer investor?
All right, I would say all in, if you're going to set up an LLC and you're going to do it with an operating agreement, the operating agreements vary in terms of cost. I'll be upfront about it. Like if it's a single member, just simple LLC, and people try to do it themselves. And Dave, this goes to what we were talking about earlier. If Dave's still here, like, I recommend always using an attorney, but yeah, can you go on the internet and pull up an operating agreement and try to do it yourself? Well, you better understand what you're doing. But some people do it, and that's fine. And then you can save a couple of bucks and do it that way. But in terms of like, it can vary depending on the type of LLC you're forming. You can be anywhere from $1,000 just to set it up and get all the operating, all your ducks in a row, from a legal perspective, and your fees, and if it's complex, it could go upwards of, $5,000-$10,000. I don't think that would ever apply to you guys in that sense, but you're looking in the $1,000 to $2,000 ballpark, generally speaking. I just saw that you can pay now or pay later. That's comment pop up. So that's like generally from a legal cost. I don't, from accounting perspective, I don't want to opine about that too much. It's not really, it shouldn't be, if you've got one LLC, it shouldn't be too complicated and shouldn't be too expensive. Like, it depends on what they're doing to maintain your LLC. Are they doing a lot of the work in terms of paying your tax and or dealing with your tax work, or are they just like, are they acting as a registered agent? That could vary from a few $100 to $1,000 a year, possibly. And then your standard Secretary of State fees, I just said, your first one-time fee is $150. If you have to expedite it, it could be $250. And then yearly, you're going to have your annual fees, and your annual fees usually are about $100 per LLC. So hopefully that answered your question, John. I don't know.
No, that was great. One other question, it looks like Jeff had, and he's a wholesaler. So you probably see this with like realtors, wholesalers, flippers. What kind of entity structures should somebody that's doing more transactional type stuff be thinking about, if any, or does it make sense to have one?
I would say from the get-go, LLC. Always. Like, for all of you, I would say if it's investment properties, LLC. The only other options you have really are partnerships, and that gives you zero liability protection. Just passes through. It's just you have liability personally, both to your partner, and if something happens on the property, if it's owned by partnership, you have no liability protection. For you get tax benefits, but yeah, you don't get that. And then corporations, I explained, like, way too complicated. There's no reason for a corporation. You're better off doing an LLC. As somebody said, when you say partnerships, do you mean LPs? No, I'm just talking about general partnerships. People, I see this in the real estate world. People do general partnerships. There are limited partnerships where you have some limited liability, but that might limit as to what it's invested in, but you still could have exposure 100% to your other owner or other partners. So again, like if you have guarantees and stuff on loans and things like that, or if you get into let's say one member gets involved in an invoicing or something issue with a vendor, it's still less liability protection. Your limited liability company is still going to be the better way to go. Cody just sent me. I'm sorry, I'm popping up this question. This is actually a really, really, really good question because it's something I meant to talk about. Insurance. That before, when I was saying, hey, you want to put each individual property in an LLC. Insurance is something you also have to think about. Again, if you have insurance policy of $1 million and you have a property worth $100,000, but you have 10 properties on 100,000, it's probably why you're going to have enough protection for that under insurance. Now, that doesn't mean that you still don't want liability insurance or liability protection as a limited liability company. You kind of want to do them in conjunction with one another. The reason why you want to do that is because, one, you've got anonymity reasons. You personally don't want to be sued, but then you have to, and each individual is going to have a different scenario with the property insurance. There are things that insurance might not cover. You got to read the type of policy you have, and there's scenarios that could exist where, guess what? I'm not protected under this scenario under my policy, and guess what? You have liability. You thought you're going to have protection just under insurance. But generally speaking, what I tell most people is, hey, you've got insurance that's covering, and you have umbrella insurance that's covering a certain dollar figure. There's no harm in putting 3 properties under that one LLC, but just don't forget that, like, if, let's say, a tenant has this horrific accident, your umbrella insurance, let's say for hypothetical reasons, is only $500,000, and they have one of the properties burned down and the 30 people in there. Guess what? That umbrella insurance ain't going to protect you too much. You're going to have a significant exposure on that end. So everybody's got a very different risk tolerance. I, as an attorney, I'm always like risk averse as best as possible. I want to protect myself in any which way as possible. And some people are like, hey, what are the chances that I'm going to have this horrific, tragic fire that occurs in my property and I'm going to have liability exposure on that? Like, there's no perfect formula for that. It's only in your mind, and something I would gladly discuss. And I can tell you the pros and cons. Hey, these are the scenarios, just like I kind of talked about here with some of the questions that John raised. But everybody's going to have their different scenario, what they're comfortable with, what they want to spend money on, and go from there. But I can't ever give a straight answer as to, hey, this is exactly what we should do.
I had one quick question. So I have one partner who has quite a bit of anonymity. He has a Delaware statutory trust that holds the membership interest in one of our partnerships. Speak to me about that. Does that make any sense? Or is that because if there was ever a problem, wouldn't somebody find a way to figure out who that person is? Like, why would you have all those layers? I guess I've always been curious about that.
So I also saw Cody had a question, but I'll look at your question in a second, Cody. Sorry about that. Just gotta try to focus on this because it seems to go hand in hand.
Yeah.
Okay. What? So are you saying that person has a trust and that trust is the member of an LLC?
Correct. Yeah.
Okay.
And it's a Delaware statutory trust, right? So it's supposedly hard to pierce and all that.
Here's the great thing about Delaware. Delaware, it's really hard to find out who the member is. So under Delaware, you can't find out that member as easily as you can in Illinois. So if you tell me your LLC right now name, I can pop it right into Secretary of State website and get you an answer in like 10 seconds about I'll be like, here are who the members are. But again, to get that information, okay, now you have the trust, then you have to go and dig in to go get that trust information and go start perusing to get that information. Most people are not doing that. Attorneys who are smart enough, who know what they're doing, and litigation attorneys, I know how to do it. Well, we can dig and find out and eventually get to who at the bottom of who the members are. But at the end of the day, they're still protected. You've got another level of peers. So let's say your LLC wasn't being run right. Okay, fine. All right, great. Now I've pierced and I've gotten at John Warren, but the other person who has exposure is a trust. But the trust has been run correctly, so the exposure to that person is only to the trust. Does that make sense?
Yeah, I think so. So in other words, it makes it much more difficult. I guess, does it actually make it more difficult for a competent attorney that is trying to litigate though? They'll still tear through that, right?
Yeah, they have to still pierce it though. And you have to have a valid reason. I won't go to piercing of corporate veils. There are 7 different standards you have to meet before a court will allow you to pierce a corporate veil. Okay. It's hard to do. But I mean, it happens. People create sham corporations, LLCs, et cetera, for all the time. They do. And there's valid reasons to pierce, but it's hard to do. Competent attorneys know what they're doing. It's still the law is a law. It doesn't matter. And if you've been abiding by law and you can present that position, it's we did everything X, Y, and Z. So the judge will be like, yeah, can't pierce. Sorry, you can't get to that person's personal assets. Goodbye.
I guess the 2 good follow-up questions there. Cody had one.
Yeah, I didn't read Cody's. I'm sorry.
No, good. And then
unless you want to read it, why don't you read it to me?
Yeah, no worries. So Illinois LLCs are not anonymous, which is pretty true. And then the second one from one of the other members, I don't know who that is. If you design with a foreign manager managed LLC, it can be achieved.
When they mean foreign, I'm assuming not of this country then.
I have
Is that what you mean? Cody, you can get, yeah.
Out of state.
You mean out of state?
Yeah. Okay. Sorry, I didn't, because I thought I answered that question before. Yeah. If a foreign, you just have to have a registered agent here.
No. They were responding to my statement that Illinois LLCs aren't anonymous. I looked up 5 of them while we were just talking. It's super easy because it shows the manager, and they were saying that if you use a foreign manager managed LLC, then you might be able to do it. But ultimately, you got to find a state that will accept an LLC that's anonymous in the first place. There's got to be a route there.
Okay. Yeah. No, you're right. Exactly. That's what we were saying about Delaware. It's harder to find. Yeah.
Yeah. Or Nevada.
Do that, but then you can still, as an attorney, you can still pierce and do a lot of things to go find out that information. But it's a smart way of doing it if you're really. But again, that type of asset protection is going to cost a lot of money and a lot of a headache to do it. It's probably, you're never going to get, I'm not saying never, but that situation probably won't arise where you're getting somebody who's digging into it. And they still have to pierce. As long as your company's run and like your contract, one example I'll give is you got a vendor contract, and the vendor contract is between your LLC and said vendor. I don't know, like heating and an HVAC vendor, right? And you breach, you never paid them. They can only go after your LLC. They can't go after you individually, even if they know who the member and manager is. It doesn't matter. They have to pierce the veil and show that your LLC is not operating in a way that's in good standing and pierce through it to get their judgment. Makes sense?
I think the anonymity really comes down to you don't want people to be able to figure out how much you're worth to make you a target in the first place. It's not really a liability thing. It's an obfuscation thing.
Well, I mean, anonymity also for the sake of, like you don't want people knowing that you own these properties like, right? I mean, that's really the biggest thing. You don't want, I can pull up everybody's deed.
Mm-hmm.
Right now. I can probably, if I know the address, I can pull up the deed and I know who owns it. I know, okay, well, they
Does
have.
it tell you what state their LLC is too?
Which one? I'm sorry.
When you pull up the deed, does it tell you where this?
Yes, it's supposed to.
Okay.
If they did the deed correctly, anytime I do a deed, it'll say John Smith LLC, Illinois Limited Liability Company in good standing.
Yeah, because my LLCs are in South Dakota.
Yeah, it'll say South Dakota.
I don't know why. My attorney just said South Dakota at the time. That was back 2017. They just want me to do it.
I don't know anything about South Dakota LLCs. There might be.
That's exactly why it's there.
there might be there might be a good reason for it, but like that's not one of the ones that sticks out as like for favorable law and tax purposes, etc. Why South Dakota?
This was the time when Illinois have ridiculous price on Sirius LLC. So
yeah, so that might be. Well, Sirius has been around longer than 2017, but
for Illinois, that's why like it was like every other series is like $300 something. It's crazy.
Exactly. Yeah, that's why somebody's just saying, is it worth getting a series? My answer always, by the way, to that series question, I get it all the time. More often than not, is like, there's no point. And I use that example of that law firm or that company that I represented that got sued. All that money he allegedly saved in setting up all these LLCs, he spent on my attorney fees to dismiss the case against them. Like, so, at the end of the day, I didn't find it worth it.
I think the advantage of that is you only file for one taxes.
Correct. And that's, I think I alluded to that earlier, like the tax benefit is worth it. Like the headache of the tax accounting, and you're probably going to save money with your accountant on that end because you don't have multiple LLCs where you have to fill out all the separate paperwork and you have separate accounts. I mean, by the way, don't forget, you're always going to have separate accounts. Although they're series LLCs, each series LLC has to have its own series LLC bank account. So it's not like you cover everything under and people screw that up a bit. And then that starts creating that piercing of the corporate veil issue that starts getting hairy. Although they're called series LLCs, although they're separate entities, they should be treated still like separate entities, even though they're related. But for tax purposes, there's a significant benefit.
Bibek,
maybe John, you might want that as a presenter next time, an accountant, right?
It's funny you say that. I think our next one is an accountant. I think my accountant's coming on.
You guys should write down these questions because they're great questions and they will very well be able to answer those from tax purposes.
So we are rounding this out. We have about 5 minutes left. Bibek, one thing I was hoping you would at least mention or maybe talk about a little bit is the new Cook County tenant landlord ordinance thing that just passed that is going into effect in like 6 days. Can you give us the high level? What's changing? All
right. Well, first, before I even get to that, one really good bit of news that you guys probably may have heard by now is that Pritzker is saying he's going to lift the moratorium by August, which means I may be very busy come August. So I don't know how much I'll be answering. No, I'm kidding. But we'll see where that goes. Again, I think maybe all of you have heard on the eviction level that the CDC case was appealed. It's up on appeal. It's still in play. And until the appellate court, it's decided up on the higher level from the feds, from the appellate court in terms of whether that the CDC has standing to enforce, at least that's still end of June. I don't know what Pritzker means when he says, I'm going to slowly phase it out. I don't know what that means. So from an eviction standpoint, I just want to I kept meaning to mention that. I don't know, John, if anybody's coming to talk about evictions, I do evictions as well. I usually do more high level evictions, but I do handle them and can give advice on that end. But that's starting to come to an end. And I think for investment property people, maybe you've had that person who's sticking in there and knows the law and whatever, but you can probably stick it in their face like, come August, I'm going to get you out. So what do you want to do? You know, might be something to think about. Now, the Cook County RTLO, not RLTO, boy, high level. First of all, there's if you have been doing lease renewals, and from my understanding, and I've done a lot of legal education on this, I'll tell you, us attorneys are still like, it's not the greatest written thing, and we don't know how a lot of this stuff is going to play out. All right. But I'll say, if you are doing renewals already and you're renewing existing leases, then your renewals, you better be compliant also. Meaning that if you're supposed to add the Cook County RTLO addendum and give that to the tenant, you're supposed to provide move-in fee information, all that stuff. You should be doing that and being compliant, because you're going to, like, security deposit information. You should be compliant with the new RTLO code and make sure all of that stuff is buttoned up, even on the renewals. Like, I know you guys have till June 1st, but if you've been doing renewals and you've been doing them and they're going to go into this after June 1st and the term is going to go in there, go and fix that. Now, I don't know if anybody's going to be, I'm just telling this as hopefully, John, you don't give this to plaintiffs' attorneys, but I don't know if anybody's going to go and start suing people for that. Like, oh, you violated that.
Is that for just Chicago or any Cook County?
Cook County suburbs. City of Chicago is still governed by the RLTO. So you're going to technically have two leases, and you should. All right. I know people are trying to merge them. All right. Some are more restrictive than others. And there are areas where like the suburb one's more restrictive than Chicago, and Chicago's more restrictive than the suburb one. And I have this conversation where I represent a lot of property managers. So I have this conversation with them all the time, because they want to really streamline the process, because it's more paperwork, it's more difficult. Oh, what if I use just the Chicago the Cook County RTLO, and I use it in DuPage? Well, you're now creating a contractual obligation for yourself that you didn't have in DuPage, because now you just push all these Cook County restrictive things that have passed by ordinance onto yourself, and now you have a contractual obligation. So I don't see why you would do that. You're just creating more liability just to save yourself the paperwork. So from that aspect, there are a lot of different nuances and changes. The one good change that I love about the new RTLO, I keep screwing the two things up. The RTLO is there is a cure period. You have a 2-day cure period. The tenant has to notify you failed to give them their security deposit information. You have 2 days to fix that. So if you ever get something like that, fix the issue, fix it immediately, and get it done. And unlike Chicago RLTO, it's not just straight up strict liability. All right. Because you didn't give the security deposit information, and the bank is held once you do it, you're screwed in Chicago, right? It's done. It's a violation. If a plaintiff's attorney gets wind of it and you're sued, you're going to owe it. So you might as well just pay it and just be done with it. But the Cook County RTLO affords you that protection. Lockouts have not been allowed since January, so I hope you guys aren't doing that. There are addendums to add. There's paperwork that needs to be done. Move-in fees. They're really being restrictive about this. Essentially, they're trying to, from a legislative standpoint, they know that landlords were trying to skirt the security deposit by taking move-in fees. And you guys know, as a general rule of thumb, don't ever accept more than 50% of 1 month's rent as a move-in fee. It'll be considered a security deposit. If it smells like a duck, quacks like a duck, walks like a duck, it is a duck. And that's the way the court's going to look at it. So for you guys' protection, if you're not sure and you're really towing the line, I'm not a big fan of towing the line. They're putting these laws into because they're bad actors, and that's why they're in place. And yeah, there's some things that are quite plaintiff friendly and it's tenant friendly. You guys know it, you guys understand it, but if you follow the rules, you're in pretty good shape.
Bibek, so like, what are some, like, cause I know I want to be respectful of time and we're getting close to the end here. What are like the high level changes? I know there was the 60-day renewal notice thing in there, cause I just went to a guidance session or whatever you'll call it from the Illinois Association of Realtors. It's like 60 days renewal.
Yeah,
Late
I'm
fees
trying
were
to remember
changed?
because I've got all of them in my head. If you give me 1 second here, I'm just popping something up for you.
No, that's right. I know the most egregious to me was the late fees being capped at $10 for the first $1,000.
Yes, that's
of
one
rent.
of them. At $1,000, it's capped at 10, and then it's 5% for everything over the 1,000. You guys understand that? Even I have trouble with that one.
Essentially, for most of us, just charge $10 because it's not worth the math for the extra.
Exactly.
$8
Unless you have like a $10,000 tenant, a month tenant,
Right.
then it makes sense. So yeah, I would, no lockouts. Hold on 1 sec. I'm just trying to think. I'm looking at the things just to see what other ones that we can do. Hold on 1 second here.
Is that $10 per month total?
So late fee is $10 if the rent is $1,000 or less for month. So if rent's due by the 5th, then you assess a late fee.
It's a hard cap, Chris. You can't do like a percentage or, I used to do like a straight $50 moving fee.
And just so you know,
or late fee.
And if rent is more, the late fee is $10 plus 5% of the amount over $1,000. So if 5% of 500, so it's $1,500. You can charge 5% on that $500. Does that make sense?
You can still only get like $35.
What's up? Yeah.
You still only get like $35. Yeah, it's not much.
Okay. I'm trying to think of other. You have to give 60-day notice for non-renewals. If you don't give them notice, the 60-day notice, they get to stay 120. I'm trying to think
Do
of
we need
anything
to
else.
reissue our existing leases or just wait till they come up again now?
Okay, so there's an addendum. Actually, John, can I just email this to you? You should just send this to everybody.
Yeah, I'll try to include it on the kind of the follow-up email here where we send out the link to the recording. That way everybody
All right,
has it.
John, I'm just sending this to you. This is it's called a summary of Cook County. I'm giving you, there are 2 of them. I'm giving you, one's newer than the other. I believe there's one that's labeled May of 2021, but this you're required to give your tenants. Okay.
Yeah.
There are also CRRTLO exhibits. I'll give this to you too, John, but this is probably a more bigger topic to talk about all these things.
Yeah, no, I mean, we were just looking for high level. I think it's good for people to know this exists since it's going into effect and it's been rushed through, in my opinion.
It's been rushed through. And here's the thing. And this is advice I give a lot of my clients is hey, I don't like people going off the reservation, creating their own leases because there's a lot of chance of screwing something up. And I say, hey, go with the basic, whatever Illinois Realtors provides for your RLTO, Chicago RLTO leases. Use that because everybody's using it. So you have less of a chance of getting in trouble with it. If you don't fill out the security deposit information, bad on you, but so right now, nobody's really taken the initiative of trying to do the lease that you guys have a template one that everybody can use. They were working on it and some different realtor associations, but nobody's really, so it kind of puts everybody in a bind. So I've just been saying, give the summary, read the summary, understand the summary, and then it talks about management fees and stuff. You guys also have to give out utility fees. If you're charging the tenant utilities, you have to notify the tenant utilities of the utility charges, and you have to give that breakdown. And then you have to give, if you're charging an administrative, you have to advise us to all the fees. That's different than the Chicago RLTO. You don't have to do that in Chicago. So that's why I'm saying if you're starting to combine the leases, then you're making yourself do things that you have to do in Cook County suburbs that you didn't have to do in the RLTO. So it might not make sense to do that.
Yeah, like I said, I sat through that 1-hour session with Illinois Association of Realtors. They had an attorney, they had a high-level property manager, they had a couple different people, and they don't have anything worked out yet. Yeah, they got nothing worked out yet. No leases. They're figuring it out still.
They're still figuring it out. So I gave the exhibits. I think, read through them, do what you have to. It's gonna be interesting. There are a lot of plaintiffs' attorneys that are licking their lips right now.
Yep.
And
Yep.
everybody's just gonna we're gonna have to get through it, right?
So screen your tenants and keep your credit scores really high, so you help to avoid. It's going to do the exact opposite of what all those wonderful,
Yeah.
people are hoping
look, I
for.
always
Second
tell
order
I have
effects.
Yeah, I have clients who collect security bills. Like, you just saved yourself a whole lot of headaches.
Yep.
But if it's worth it for you to not get security deposits, then you just save yourself a lot of potential for liability. I'm not saying you're doing it wrong, but you better make sure your stuff is buttoned up.
That's awesome. Bibek, thank you so much, man. Thanks for your time
No
tonight.
worries.
Really, really great presentation. And thanks everybody for coming. We will be back here same time, same place, same bad channel next month.
Nice.
And I am looking for in-person venues because I know many of you, like me, have gotten the vaccine and you're ready to eat burgers, grab a drink with friends. And next month is my accountant is the guest, so that'll be really fun.
Yes, great.
So it'll be a good follow-up to having Bibek come through. So thanks again, all.
Awesome.
I'll share that information that Bibek sent over, and get ready for the new ordinance. It's coming. Awesome. So have a